Class, welcome to week 5 of our contracts law class. I wanted to go over a certain amount of the subject matter before you get into the book and before you start your detailed work for this week, because there's going to be some confusing aspects of our learning for this week. So I wanted to go over them, make sure that you understand them from a higher level before you get into the specifics of some of the cases and other things that explain these concepts. Now, as you remember, part of a contract has to do with mutual assent. That means that people have to agree that they are all involved in the same exact contract. And once they agree to that and the other elements of contract are there, then there are certain defenses that can come up that test the genuineness of that mutual assent. These will be mistake, misrepresentation, duress, and undue influence. The one I want to go over with you this week is mistake, because it's one of the areas that has confused students in the past, and I anticipate that it will do so again. So let's go into mistake and get into that in some detail just to get you warmed up for that concept. And I think the rest of it should do, you should be able to do it on your own without too much problem. And of course, if you have any problems at all, please feel free to call or email me on anything having to do with this week's work. All right, so a mistake. A mistake occurs when one or both of the parties have an erroneous belief about the subject matter of the contract, which could also be value of the contract or some other aspect of the contract. So in essence, when there's misinformation on the part of at least one, but sometimes both of the parties, then we at least have a possibility that there's a defense to this contract or the enforceability of that contract based on this defense called mistake. And mistakes can either be unilateral or mutual. Unilateral, of course, is where one party is making a mistake, and the other is where both parties are making a mistake. So an example of a unilateral mistake would be I'm selling a painting at a garage sale that I think is just a copy of a Rembrandt. It turns out it's an actual original. I sold it for $10. I'm making a big mistake, obviously. The other person may have known it was an original. And if that's the case, then it's a unilateral mistake. If both of us thought it was a copy and it turns out to be an original, then there is a mutual mistake. And the law regarding whether it's a unilateral or mutual is quite different, so we have to figure out that before we go any further. All right, unilateral mistake, of course, happens when one party is mistaken about some important or material fact regarding the subject matter of the contract. Without that, we don't have mistake in the terms of a defense to a contract. It has to be something very important. It can't be something trivial. So we've got to make sure that before we allow the rescission of this contract that would otherwise be enforceable, that there's an important aspect of the contract that at least one party is mistaken about. Now, that means also that if we're successful on this unilateral mistake defense, we will actually have the court rescind the contract and put it aside as if it never actually happened, put everyone back to square one as if the contract had never been entered into, and we go our separate ways. So, unilateral mistake. There are three types in which we can have a possibility of having this defense work. The first one would be one party makes a unilateral mistake of fact and the other party knew or should have known that the mistake was made. That means in my garage sale example, I don't know that the painting is an original. The person who I'm selling it to happens to be an antiquities dealer, knows very well that the Rembrandt that I'm selling to them is an original, and they're picking it up for $10. That's a unilateral mistake of fact. I did not know that it was an original. The other party knew or should have known that a mistake was being made by me, because you don't sell a Rembrandt for $10. And that would be a good example of this first type. Also, a unilateral mistake occurs because of a clerical or mathematical error that is not the result of gross negligence. Instead of putting in $10, which is the price, we put in $100, and it's not the correct price, and it's obviously not. And if that's the case, and it's not the result of gross negligence, then that could be another type of unilateral mistake where the contract can either be rescinded or possibly reformed to put the correct figure into the contract. The mistake can be, if the mistake is so serious that enforcing the contract would be unconscionable, then we can also have a unilateral mistake. So we only have to have these three different ways. And if we have any of those different ways, we can either have the contract rescinded, get our money back, parties go their separate ways, or in the case of a unilateral mistake where it's a clerical error, we can also have the contract reformed if there's So if we have any of these three different ways that a unilateral mistake can happen, then we have a defense to the. So when you're looking for a unilateral mistake, have this list of possibilities in front of you, and then look at the factual circumstance and see if you can find any of these in terms of whether they are appropriate for that particular situation. If they are, or any of them are, then you have a chance on having a way of getting out of a contract through a defense to an enforceable contract. Now let's look at mutual mistake of fact, which is the second kind of mistake that can be made as a defense to a contract. So if a mistake is made by both parties concerning a material, that means important fact about the subject matter of the contract, then absolutely, then the contract will be rescinded. It'll be on the ground that there was no contract formed because there was no meeting of the minds. There was no true assent between the parties because each party was mistaken as to what was going on. Thus, in my garage sale example, if I was selling the Rembrandt, I thought it was a copy. My buyer thought it was a copy also, and it turns out it's an original. Then both parties are mistaken about a very important fact about that painting, and thus the contract will be rescinded as both parties thought they were selling a copy when in fact they were selling the original, and that's very material to the subject matter of the contract. I hope that helps you understand this a little bit better. Again, this is the area I think you will be a little bit confused with, so please feel free to give me a call if you're having any further confusion about this issue, and call me early on to make it as helpful to you as possible. You can, again, email me or call me. You can also text me. Either way, please do give me a call if you need any further clarification. All right, we'll see you in the discussion boards this week.